What happens if you die before you sign your will or your trust? What happens with the land? Where does it go? This is a question that comes up often in the estate planning consult. Find out next in this video. Hi, I'm Jason Wagner, the farm lawyer. I work with farm families every single day to help them pass on the farm to the next generation. This is a question that usually comes up in the estate planning consult. You know, the client says it's taken us 5 years to get here, maybe longer in some cases, and now we're ready to make decisions, but they're in this mindset. We're ready to think about it. We're thinking about what happens with our stuff, with the land, with the farm, if we're no longer here. And, you know, you may have thought those things quietly in your mind. You might have talked about them at home a little bit, but now it's out in the open. We're talking about it, and all of a sudden it's very real. What happens if we made it this far, but we don't sign it before we die? Well, first off, I want you to just take a deep breath. You're probably going to sign it before you die. That's why we're here. You know, if working at our office, we try to get that thing moving along fairly quickly because we know that you've taken a lot of time getting to the point that you're ready to put it together, and we don't want to slow things down for you. But, you know, let's say you're in that 5-year span before you actually do get to us, and then something happens. What are the default rules? So if you're married, we have to think about is if you don't have a will, then typically that's going to go to your spouse. A lot of land is owned jointly, or a lot of property is owned as joint tenants, which means that automatically goes to the survivor if something happens to one of you. Bank accounts can be owned that way. You see that, you know, if you bought land during your marriage, probably it's joint tenants. The other thing is it could be owned as tenants in common, or if it's only in one person's name. Now, that is where we could end up in probate. And if we don't have a will, we're going to have to fall into the laws of intestacy. And those generally say that it would go to your spouse. However, it may be that the homestead goes to the spouse with a life estate and the remainder to the kids. And that can sneak up on people. They may not realize that. But that's what will happen if you don't own the land as joint tenants. If you're not married, that's where it would go to all of the kids in equal shares. So people ask, well, what about your notes that you took down there? Can't you just make that valid? Well, unfortunately, unless it's in a, you know, signed witness testamentary document that says this is my last will and testament, or it's set forth in a trust, those don't carry a whole lot of weight. It's not enough to meet the standard as a testamentary document. So that's why it's important that you don't put this off. I know these are tough conversations, and I know that you want to get it right. But we like to think about estate planning as not a one-time event. We want to make sure we've got that good, solid foundation. We get our foundational documents in place with the will, trust, power of attorney, healthcare directive, and that makes it so much easier for us to go in and edit and modify and update over time because we're not having to create that entire foundation. It is easier for you to keep your estate plan updated once you've gone through it, you know, that first time, get your trust in place. Now we've got something to work from, build from, and edit as we go and make sure it's reflecting the situation, or maybe you've changed your mind or things have come a little clearer on how you want things to happen. But what we don't want is for you to sit there for 20 years, get nothing done, and then for everything to fall apart because you put off the planning. We also don't want you to put the estate plan in place and then don't touch it for 20 years, because that's almost as bad as doing nothing at all. It's very likely that things have changed in those circumstances as well. So our big recommendation, get that foundational estate plan done. If you have to make updates as you go, then we do it. Not a big deal, right? We can do that. But you don't want to just leave things off and not do anything because you're worried about getting it wrong. Because the default is that everything just goes to your spouse or goes to your kids in equal shares. And if that's not what you want to happen, then we need to make sure that we write that down. If you like what you heard or want to hear more, follow me. I'm the Farm Lawyer. Drop a comment below. Let me know what you think.